Major breaking news out of the United States Supreme Court late tonight. The United States Department of Justice, on behalf of the Biden administration, has filed a major brief in the United States Supreme Court's Second Amendment case, the United States of America versus Rahimi. This is a question whether or not 18 U.S.C. 922 G8, dealing with so-called domestic violence restraining orders, whether it's constitutional under the Second Amendment facially. This is a very big deal. If you find out what the Department of Justice is arguing, you're going to be shocked in terms of how they're trying to gut the Second Amendment's right to keep and bear arms. Stay tuned. Hey folks, I'm Mark Smith, host of the 4Box Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Don't forget to follow me on Twitter as well, at 4Boxes Diner. All right, major brief late tonight at around 11 p.m. Eastern Time. The United States Department of Justice filed a brief in the Rahimi case, which is a major Second Amendment case, the next Second Amendment case to be decided by the U.S. Supreme Court, and it is crazy what they're arguing. Specifically, they are arguing that the Second Amendment allows Congress and legislatures and government to disarm people who are not law-abiding and not responsible. Hear what I just said? Not law-abiding and not responsible, with no real limits to the concept, which means that if you engage in jaywalking, if you go 60 miles per hour in a 55 mile per hour zone, if you somehow show that you're not responsible, whatever that means, then according to the Department of Justice submission, in the Rahimi case, you can be disarmed. Now, to step back for a second, just to remind you what the facts of Rahimi are and what's going on in Rahimi. The question presented in Rahimi, according to the Department of Justice and the U.S. Supreme Court, is whether 18 U.S.C. 922 G8, which prohibits the possession of firearms by individuals who are subject to domestic violence protective orders, whether or not this law violates the Second Amendment on its face. Now, this is important because the Department of Justice says on its face, which means they're arguing that there are at least some instances where this law is constitutional under the Second Amendment. Now, it's important that you understand, because I've told you before that I was concerned about this Rahimi case, because Mr. Rahimi, based on the record, does not appear to be a Boy Scout. And what I mean by that is, if you look at the record, which I'm now looking at the brief here, and I'll put a link to the brief that they submit. If you look at what they argue that he did, and it appears to be true based on the record at least, in December of 2019, Mr. Rahimi and his girlfriend, with whom they share a child, had an argument in a parking lot, and Mr. Rahimi threatened to take the child away, and when the girlfriend tried to leave, he grabbed her wrist and knocked her to the ground. He then dragged her back to the car. He picked her up and pushed her inside, causing her to hit her head on the dashboard. Realizing that a bystander had seen him, Mr. Rahimi retrieved a gun and fired at the witness. In the meantime, the girlfriend escaped the car and fled. Rahimi later called her and threatened to shoot her if she told anyone about the assault. That was in December 2019. The reason why that's significant is that in February of 2020, she sought a restraining order against him on the grounds that she feared for her life. Mr. Rahimi admitted effectively to this violent activity. He was given a copy of the protective order and did not object to it. And on that restraining order, it indicated that he did engage in family violence, among other things. And he signed it and swore to it that he was on board with it, which I think is going to potentially be significant in this case. Nevertheless, again, those are the facts. The Fifth Circuit Court of Appeals said that the law, the federal law itself, is unconstitutional under the Second Amendment. That doesn't mean that Mr. Rahimi goes free, of course. He can be prosecuted for all sorts of things under state law, maybe even under other federal laws, but certainly under state law, because as you know, we've talked about this before, laws such as murder, assault, battery, rape, fraud, and the like, these are already crimes. Now, the reason why this is significant, if you look at how the Department of Justice is arguing this case, they are laser focused on trying to connect the dots between guns and domestic violence. And they define domestic violence as, of course, interfamily violence, husband, wife, boyfriend, girlfriend, child, whatnot. And the reason why it's significant is of course, they beg a serious question, which is they talk about how guns and domestic violence don't go together and all that, which obviously is true in the sense that domestic violence is already a crime. Whether someone uses a gun or a knife or their hands or a rope or whatever to engage in violence, assault, murder, rape, robbery, whatever it is, these are already crimes. So what the Department of Justice is trying to say is that they want to be able, and you can see what's going on here, they're setting this up to justify red flag laws. They want to be able to take away guns from people that they, i.e. Congress, state legislatures, the government, define as not responsible and law-abiding. Now, here's the key. The phrase law-abiding and responsible appears in many instances in the Heller case in 2008, the Supreme Court decision that says that the D.C. gun ban, that says that you have a right to a loaded handgun in your home ready for self-defense. They use the phrase law-abiding and responsible. They also use that phrase in Bruin. The reason why they use this phrase, though, is because they're just trying to make the distinction to show that the people they're talking about in those cases, there was no dispute, there was a problem with it. There's nothing magical about that. That language is what we've talked about before, is known as dicta, which means it's part of the opinion, yes, but it's not the central holding. The Supreme Court has never said that the only people that are allowed to have guns are law-abiding and responsible, because we all know that law-abiding is very broad in a world that we live in today, where there's an infinite number of not just malum in se crimes, such as murder and rape and things that are evil in and of themselves, but also infinite numbers of malum prohibitum crimes, everything from failing to recycle properly to putting out maybe bird seed where there's bears around and you violate some fish and wildlife rule or something. Who knows? There's so many laws out there. And you can see what the anti-gunners are trying to do in the Department of Justice. They're trying to say law-abiding, conveniently ignoring the fact that the real standard should be, is someone dangerous? Which, again, we'll talk more about this in the future. But anyway, if you look at the argument in this brief, which I'll put a link to down below, they have three main points as to why they can take guns away from people that are not law-abiding and not responsible. And that is, they say the court's precedents point this out. They use the language in both Heller and Bruin. But again, as I point out, that's dicta. That's not the central holding. And in those cases, the plaintiffs that brought those Second Amendment challenges, there was no dispute. They were law-abiding and responsible Americans. And that's why the court used that language. It wasn't anything magical about the language in and of itself. It wasn't a holding. Number two is they talked about the history. In their history argument, they say the history allows them to be able to disarm people that are not law-abiding and responsible. They talk about a whole host of laws at the time of the founding, including, for example, taking guns away from Tories who would not sign oaths in favor of the patriot causes and things along these lines. So those are a whole host of laws. They also, of course, try to use the argument that tradition allows this to be the case. They talk a lot about the 19th century, but again, we've talked about this, that at the founding era, 1791 is when you interpret the scope of the Second Amendment. The 19th century history can only serve as a confirmatory analytic. I think the Supreme Court's finally going to nail this down, because I think they're going to need to in this particular case. And I think ultimately this case, whether or not Mr. Rahimi himself wins or loses, I think there'll be a lot of issues that are, cleaned up by the Supreme Court for future lower courts. But we will see. The next thing that's critically important, and this is kind of entertaining in a sense, the Department of Justice says that there's strict rules about who is subject to these domestic violence orders that will allow you to lose your gun rights. And what's interesting is if you actually look at the language that's applicable here, which is 922G8 C, they tried, and this is the clear sleight of hand the Department of Justice does. They say that the finding has to use the following language. There has to be a finding of the following, quote, that the finding, it includes a finding that such a person represents a credible threat to the physical safety of such intimate partner or child, meaning there's a specific finding that the person subject to the restraining order is a credible threat to the physical safety of an intimate partner or child. Now, that makes some level of sense. If there's an actual finding that you're a danger to someone, one understands that logic to some degree. However, there's another way that you can lose your gun rights under 922G8 C, and that is the second part, which is much more loosey-goosey, and I don't see how this second part is possibly constitutional on its face or otherwise. This language is so generic, you'll see what I'm talking about. This is the other way you can lose your gun rights. I'd read the first one that you're found to be a credible threat, but this other one is crazy because all it does is restate that you have to follow the law generally. Here's the language, and you'll see what I'm talking about. Quote, by its terms, the restraining order explicitly prohibits the use, attempted use, or threatened use of physical force against such intimate partner or child that would reasonably be expected to cause bodily injury. Period, close quote. You hear what I just read? This is the law. This is what the law already says. There's no magical finding here. It just says that the order says, we want you to behave. We want you to follow the law. Don't break the law and engage in physical violence with someone you're friendly with or you're a family member of. Hello, it's already the law. So again, the fact that a court orders someone to follow the law is not a finding of dangerousness at all. It's a finding of literally nothing. And that is a big problem, I think, for the Department of Justice brief here. The last point they make, and again, there's 67 pages and a lot more information out there. We're going to break this down in a lot more detail. I just want to give you the heads up that this was filed late tonight. They also appeal to authority. Specifically, they have a big argument that says that most American states have these kinds of domestic restraining orders, and they get into that and say, therefore, Congress can have the same thing. We're not going to get into the specifics of this other than this is clearly an appeal to numerosity. As you know, there's plenty of states that have gotten things wrong in the past and gone off the rails, including violating the Second Amendment rights and the First Amendment rights and whatnot. So the fact that a lot of states do something wrong doesn't make it constitutional. The best example of this is a couple of terms ago, Justice John Roberts, in a case dealing with religious freedom, specifically said the fact that in the late 19th century, 30 states, the vast majority of states in the United States, restricted the use of public money for religious schools, did not make it constitutional under the First Amendment. So again, the fact that the Department of Justice and Joe Biden's lawyers are trying to argue that they can take away rights because a lot of other states do it, in addition to Congress, is not going to save the day for Congress, is my guess. But the bottom line is this, and I want to tell you finally why this phrase, law-abiding and responsible, is dangerous. What's really going on here is this. The anti-gunners are trying to create a new category of people that are going to be disarmed. They start off with everyone that's in 18 U.S.C. 922, including felons and the like. They have that entire list of what are known as prohibited people or disarmed Americans. They want to start with that. Then what they want to do, and this is key, they then want, that's what I call wholesale disarmament at a wholesale level. If you fall into one of those categories in 922G, you are disarmed, period, full stop. They now want to expand that to say that they can engage in retail disarmament, specifically to say that if there's individuals that a court, could be a left-wing blue state court, by the way, has found that someone, or it could be a rubber stamp, has found that someone is dangerous, they at a retail level get to take away that individual's right to keep and bear arms. And again, what they're trying to say is if there's a find that somehow someone is not entirely responsible or not entirely law-abiding, they speed, they don't recycle properly, whatever it is, guess what? Maybe even a civil tort could be not law-abiding, right? It's a very broad and generic definition that they're trying to get the Supreme Court to embrace. I don't think it's going to work for them. Nevertheless, it is telling where the Department of Justice is trying to take this. We will do a lot more breakdown on the details of the 67-page single-space case with a lot of citations over the next few days. But again, right now, this is a very big deal. And just to let you know, in a week or so, the amicus briefs in support of the government will be coming into the Supreme Court. We'll report on that. And then sometime in late September, early October, Mr. Rahimi's brief will be due. And then sort of the pro-Second Amendment lawyers will submit their briefs probably in early October or so. And I will keep you abreast as all of these things develop. I guess we're probably looking at an oral argument in the Rahimi case in the U.S. Supreme Court sometime in December or maybe January. All right, folks, hope you learned a little bit something here today about the Rahimi case. This is a big one, folks. There's a lot to talk about, and we'll see what happens. And again, if you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.